Let's start with this question from the top. A woman from state A was in a car accident with a business owner from state B. The woman sued the business owner for negligence in federal court. 45 days after filing the complaint, the woman personally served the business owner with a copy of the summons and the complaint at his office. The state rules on service of process are identical to the federal rules. Was the business owner properly served? Okay, this is a simple enough fact pattern and straightforward enough question. This is really testing whether you know the law. Civil procedure is in some ways kind of flat. There are often not a lot of judgment calls or reliance on the judiciary to interpret something. Often, if you've simply memorized the federal rules of civil procedure, it is enough to get you the right answer. So here the subject is civil procedure. The issue is, was service of process proper in this case? Now let's look at the rule. First, let's look at how papers can be served on an individual. We had to come up with a mnemonic because this is so utterly unmemorable otherwise. So we use the mnemonic SAID. S is for state law. Follow the state law methods where the federal court is located or where service is made. A is for agent. Deliver a copy of each to an agent appointed by the defendant or law. I is for individual. Deliver a copy of the summons and complaint to the individual personally. And D is for dwelling. Leave a copy of the summons and complaint at the individual's dwelling or usual place of abode with someone of suitable age and discretion who resides there. Here there is no state law issue since the facts say the state rules on service of process are identical to the federal rules. There is not an issue of serving an agent, and it was not served at anyone's dwelling since the facts state it was served at his office. Instead, it was served to an individual, the I in SAID. And normally, serving an individual personally is enough. So that is the method. Let's check the other parts of service, the who, what, and when. The facts say 45 days after filing the complaint, the woman personally served the business owner with a copy of the summons and complaint at his office. So let's check to make sure the who, what, and when comply with the federal rules. Who, a person who is at least 18 years old and not a party can serve. Here, the woman is a party to the case. So she is not a proper party to serve the summons and complaint. So service is really not proper. The examiners love to test these nuances, and it's great if you got the question wrong here because you will not get it wrong when you see this tested again. But let's be thorough and continue on with the what and when. So let's look at what. The summons and copy of the complaint must be served. Here the facts say they were, since it says the summons and complaint were served. When? Within 90 days of filing the complaint. Here she did so within 45 days. So everything looks good besides the fact that the woman herself served the business owner. So therefore he was not properly served. All right, let's look at the no answers first. C says no because the woman did not serve the business owner within 30 days of filing the complaint. It's not 30 days, it's 90 days. This really came clear to me when I was practicing law. I would spend all this time drafting a complaint, then I finally filed it with the court, and sometimes physically went to the court to file it. Then I had to go find the defendant and have him served with the documents. It makes sense that the default rule is 90 days. They give me basically 3 months to figure out where the heck the defendant is and how I'm going to serve him. And some of my defendants would evade service. The process server would be knocking on the door and they wouldn't answer. The process server would be trying to find them at work and such. So the court is giving me and the process server 90 days as a default rule. So C is incorrect. D says no because the woman is a party to the lawsuit. This is exactly right. One party cannot personally serve another party. The attorney for the party can, and believe me, I found myself doing this for clients when I was on a deadline, but the party themselves cannot. Now let's look at the other answers. A says yes because the business owner received actual notice of the lawsuit. But actual notice is not the requirement. Notice needs to comply with the rules. So don't get fooled by this. It is not actual notice we are looking at, it is proper notice. B says yes because delivering a copy of the summons and the complaint to the individual personally is permitted under the federal rules. That is all fine and good and true, but the issue is that a party cannot deliver a copy of the summons and complaint. It has to be a non-party who is at least 18 years old.